Good afternoon. Good afternoon. Welcome to the final round of the UCI Law Moot Court competition. My name is Emily Lovell. I am the Moot Court Board Chair. And on behalf of the entire Moot Court Board, thank you for joining us today. The Moot Court competition is one of the greatest educational experiences available to the students here at UCI Law. The mission of the UCI Law Moot Court Board is to promote the development and refinement of students' legal research, writing, and appellate oral advocacy skills. Each year, the board organizes this intramural moot court competition that asks students to address complex and unresolved legal issues with important policy implications. This year's competition involved a fictional case that raised engaging issues concerning justice for prisoners and sovereign immunity. This case demonstrates how procedural requirements can safeguard important institutional considerations and yet carry immense consequences for prison litigants. We hope that this case would give competitors an opportunity to take a compelling dive into how the American legal system balances efficiency and equity for the most vulnerable among us. Today, we have the honor of seeing the culmination of months of our competitors' hard work. In the fall semester, our competitors write a Supreme Court-style appellate brief in teams of 2 for the party of their choosing. In the spring semester, competitors argue both sides of the case through 2 preliminary oral argument rounds. Our finalists today then advance through 3 elimination rounds before qualifying for this final round. We are thankful for the faculty, administration, practitioners, judges, and members of the Orange County and Los Angeles legal communities that helped make this competition possible. I sincerely hope you enjoyed today's event, and please help me in welcoming Dean Parrish.
Thank you, Emily. This is one of my favorite events of the year. There's graduation, there's orientation, and this, though, is really the one what's inspiring. We get not only to see some of the very best students doing things that are really, truly amazing for second-year law students, but we also get to do it with all our new admitted students. And I think we've got dozens of admitted students in the room. If you've been recently admitted, you're here for Admitted Students Weekend, could you just raise your hand? Yeah, let's have a round of applause. To say, I know Dean Gappison in the admissions office, and if they're in this room, they're incredibly accomplished. So congratulations on that big achievement. Part of why this event is so special for us is because it really represents one of the key things that we do as a law school. One of the things we try to do is change the way that we think about law and legal institutions. We recruit faculty from all over the world, and they are some of the nation's leader researchers and scholars. We also have a strong commitment to doing well in our communities and in Southern California. We have one of the finest clinical programs in the United States, frankly, in the world. We have one of the largest public interest pro bono programs in the nation. And our students put in thousands of hours each year giving back to the local community. But if those are 2 of our core missions, the third one is to graduate absolutely fabulous lawyers. We recruit and bring in some of the very best students from around the country, and they spend 3 years with us, and then they go on to do great things. Our aspirations when we were founded 15 years ago wasn't just to graduate people with law degrees, but to graduate some of the most passionate and creative and ethical advocates out there, people who cared about their clients and people who could represent them in the courtroom and in the boardroom and in the nonprofit organizations throughout this country. This just gives students and others just a glimpse into just how talented our students are. And as a dean, it kind of makes me incredibly happy. So I have 3 things to do, and I'm going to keep it pretty short. First, I have to do some thank yous. As Emily already said, it was a tremendous amount of work, and so we have a couple of thank yous to do. I then wanted to introduce you and provide a little bit of background to tonight's program so you understand a little bit about the argument. And then we'll introduce the panel and bring them in, and the competition will begin. So this is a massive amount of work, and it's just hard to underscore how much it takes for the students and others to put on an event like this. While we're here to hear 2 outstanding students in the final rounds of the competition, it's worth noting that there were 62 competitors to begin with in 31 brief writing teams, 63 attorneys of the state and federal judges more than 75 oral arguments, 33 professors graded the competitors' Supreme Court briefs, and the faculty wanted me to add that they had to grade them 3 times each. That's a lot of work. And 12 first-year students served as bailiffs. That's a tremendous amount of work, and it wouldn't be possible for the students who weren't on the executive leadership team of the Moot Court. And so I'd like to thank the 2024 Moot Court Board. Normally I'd ask for you to wait, but I think we can do it. I think we need a round of applause after each name. So the chair, Emily Lovell. Vice chairs, Alfred Wong and Madeline Sickle. Directors of the bench brief, Millie Gonzalez and Leah Veliker. Chairs of Judicial Relations, Silai Fong, Kelsey Sutton, and Brittany Lee. And then finally, our chairs of Internal Relations, Marcela Hernandez, Grace Palchek, and Lauren Peterkin. We also wouldn't be here if it wasn't for the generosity of Buckhalter, a law firm that is sponsored this evening. And so we acknowledge their contributions and very grateful for the funding that they provide that make this competition possible. And then finally, I'd like to thank all the judges and the volunteers who made this competition a success. There really was thousands of hours put in. So those are my thank yous. We're about to introduce 2 of our finalists, and I think the round of applause here is appropriate too for Gabe Kirsch and Jay Naramatsu, who's right in the front there. This is going to be a hot bench, so I think a round of applause was definitely appropriate there before it began. Let me give you a little bit of the summary of the case, just so we're all on the same page as to what this case involves. So the case before us involves Neil Wilcox, a federal prisoner who alleges he was physically assaulted by correctional officers in prison. Wilcox is seeking to bring a federal Tort Claims Act suit for the alleged tortious conduct against the United States. Under the Tort Claims Act, a tort is defined as a claim against the United States. A tort claim against the United States shall be forever barred unless it is presented in writing to the appropriate federal agency within 2 years after such claim accrues. That's under 28 United States Code Section 2401. Wilcox was initially represented by the same attorney who represented him in his criminal proceedings. After failed attempts to secure help filing his Federal Tort Claims Act administrative claim, Wilcox fired his attorney and hired new counsel to represent him. Yet with only a month before the 2-year deadline, Wilcox acted independently to complete and deposit his administrative claim form with prison authorities for forwarding to the required federal agency, the Bureau of Prisons. The Bureau of Prisons considers the claim presented upon receipt of a Bureau-provided form at the regional office in the region in which the alleged injury occurred. While Wilcox deposited his tort claim 6 days before the 2-year limitations period, the Bureau office did not obtain and stamp the claim as received until 3 days after the 2-year deadline. In the court below, the United States argued that Wilcox's tort claim was procedurally barred because the administrative claim form was untimely, and the prison mailbox rule does not extend to litigants who are represented by counsel. Wilcox argues in his administrative claim form was timely filed because he deposited the form with the prison authorities before the deadline as entitled to the benefit of the prison mailbox rule despite having retained a lawyer. Ultimately, this court will decide the proper scope of the prison mailbox rule and whether it applies to Wilcox's administrative claim. Therefore, the United States Supreme Court granted certiorari to decide 2 issues regarding the scope of the common law prison mailbox rule, the issues that are going to be argued this afternoon. The first question, whether the prison mailbox rule applies to administrative claims brought under the Federal Tort Claims Act. And number 2, whether the prison mailbox rule applies to claims submitted by prisoners who are represented by counsel at the time the claim is submitted. For those admitted students, you will know more about the prison mailbox rule than anybody else on the planet by the time you finish this oral argument, which is impressive indeed. Okay, let me introduce the judges and then I'll be done. We really have a fabulous bench tonight, and with 3 of really the country's top jurists. Before they join us, let me just tell you a little bit about them. So first, and I'm going to go from right to left on the panel, the first is the Honorable Marcia Berzon. She's a senior United States Circuit Judge of the United States Court of Appeals for the Ninth Circuit. She served as law clerk to Justice William Brennan of the United States Supreme Court and for Judge James R. Browning of the United States Court of Appeals for the Ninth Circuit. Before she joined the United States Ninth Circuit Court of Appeals, Judge Berzon was an appellate and Supreme Court advocate at a very well-known San Francisco law firm. In addition to serving as a circuit judge, she also currently teaches as an adjunct professor at UC Law School, San Francisco. Judge Berzon assumed senior status in January of 2022. Next, serving as our chief judge is the Honorable Kim McLean Wardlaw. Judge Wardlaw has served on the Ninth Circuit Court of Appeals since her nomination in 1998. She previously served as the United States District Court for the Central District of California. Before joining the court, she was a litigation partner of the international law firm O'Melveny & Myers, and while in private practice, she was involved in a wide range of community, political, and government activities, taking leaves of absence from her practice to join the Clinton-Gore presidential transition team, where she worked with the United States Justice Department, and serving as Mayor-elect Richard Riordan's government liaison during his mayoral transition. And then finally, we have the Honorable Hernan de Vera, who is a United States District Judge for the Central District of California. Judge Vera was confirmed to serve as a federal district judge in June of 2023. He previously served as a Superior Court judge for Los Angeles County in the Juvenile Division. Prior to appointment to the state bench, he had a variety of roles. He was a partner at the well-known firm Bird Morella. He served as the head of public counsel, which is the nation's largest public interest law firm, and he was an attorney at O'Melveny & Myers. In 2010, President Obama nominated Judge Vera to serve on the board of directors of the State Justice Institute, where he has served for 13 years. He's also served on the Board of Trustees of the California State Bar and the Los Angeles County Sheriff's Civilian Oversight Commission. It's going to be an amazing evening. I'm so pleased to welcome to this year's finals of the Moot Court competition. Excuse me while we...
Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Good afternoon. This is the time and the place for hearing the appeal in United States versus Neil Wilcox. Would counsel for the petitioner like to come up?
Chief Justice, may it please the court, I'd like to reserve 3 minutes for rebuttal.
You may do so.
Thank you, Your Honor. My name is Gabe Kirsch. I represent petitioner, United States. In the case at bar, this court should reverse the First Circuit's ruling and preclude the prison mailbox rule from respondents' FTCA claims for 2 key reasons. First, the FTCA requires actual receipt to satisfy its presentment clause due to Chevron deference. And second, the ruling in Houston is premised on the lack of choice pro se prisoners have over their filings, a lack of choice that is absent for represented litigants such as respondent. Now, beginning with my first issue, there are 3 sources of statutory...
Wait, let me stop you there, counsel. I can't let one of your comments go by unaddressed. You said that we should give this Chevron deference.
Yes, Your Honor.
But is this really an agency that has expertise? I mean, you're relying on a DOJ reg, right? This is not an agency that has expertise in a specific subject matter. So why should we give Chevron deference? And I'm sure you're familiar with the considerable concerns that we have about that doctrine. It hasn't been applied in a long time, and there's still much to be said about that doctrine. So does your entire argument depend on Chevron deference? And if so, why should we apply it here?
Well, Your Honor, my entire argument does not depend on Chevron deference, although I do urge the court to apply it here. Even if Chevron deference is not applied, administrative regulations still carry the force of law. Quoting from the Supreme Court in Chrysler Court v. Brown, this court stated that it has been established in a variety of contexts that properly promulgated substantive agency regulations have the force and effect of law. So even if one does not apply Chevron deference, the regulations listed out by the DOJ, which define presentment in the FTCA.
So what does the regulations say that you want us to rigorously enforce?
So the regulation of the DOJ, 28 CFR 14.2 says, quote, "A claim shall be deemed to have been presented when a federal agency receives from a claimant his duly authorized agent or legal representative and executed standard Form 95. Now, so that language interprets the FTCA's.
Okay, so in this instance, the prisoner did give his claim form to somebody whom we could certainly have thought of as a representative of the Bureau of Prisons, no?
Not necessarily, Your Honor. Also, within that language, the language surrounding the representative is the prisoner's representative. So the claimant received by the federal agency from the legal representative of the prisoner.
But the point is that the defendants in this case are the guards at the very prison where he was beat up, right? So why wouldn't handing it to the prison mail system be adequate in this particular case? Never mind in general, but in this particular case.
Well, because, Your Honor, the specific language of the Code of Federal Regulations defining presentment requires actual receipt by the Bureau of Prisons office.
But that's not quite right. That language says, shall be deemed to have been presented when a federal agency. It doesn't say a federal agency's headquarters. It doesn't say their main office. And you're relying on what's essentially just some factual information later that comes in. But the actual operative CFR just says a federal agency. So how does that make it any clearer?
Yes, Your Honor. So there's another regulation at issue in this case, that being DOJ's regulation 28 CFR 543.32, which further defines what receipt by a federal agency means within the context of the Bureau of Prisons.
But isn't that just like a frequently asked question when you see on a website an FAQ? Where do I go to do this? Where do I go to do that? It's just signage, really.
No, Your Honor, it's not just signage. This is a promulgated regulation that was passed through, that went through notice and comment period. It's codified.
What does it say?
The regulation says, quote, "The presentment date is the date your submission containing all required signatures and necessary information is first received by either the Department of Justice or an office of the Bureau of Prisons."
And again, to repeat my question, that's not terribly clear to a prisoner who does hand the claim to an official of the prison, right?
Yes, Your Honor.
So why isn't that adequate?
It's not adequate, Your Honor, because the Congress and the federal agency have
But I
spoken.
want to know what in that regulation tells him that handing it over to a officer of the prison isn't handing it over to the Bureau of Prisons.
Well, the reason for that, Your Honor, is because the Fairview Correctional Facility where respondent is being held is not an office of the Bureau of Prisons. The Code of Federal Regulations specifically requires it to be received by an office of the Bureau of Prisons. And even further, in a DOJ program statement promulgated by the BOP Director, Harley Lappin, DOJ program statement 1320.06.
Which is not a regulation.
Not a regulation, Your Honor, but the regulatory body administering this regulation's interpretation of the ambiguous, if it even is considered ambiguous, which I would argue is not, language in that regulation.
So then, aside from the fact that the court has in general applied well, it has in Houston applied the mailbox rule in an instance in which the statute said file, and they said, well, but file in the context of a prisoner means putting it in the prison mailbox. So how is this different in terms of its relationship to the governing language?
Well, a couple things, Your Honor. First of all, that wasn't a statute in the case of Houston. That was the Federal Rules of Appellate Procedure, which are not statutory. They don't have the same force and effect as the FTCA. Furthermore,
I don't.
But you're relying more on the regulation than the actual statute, because if you were relying on the statute itself, we'd be examining what presents means, not looking at the definition of present in a regulation.
Well, yes, Your Honor, but returning to the point, Chevron deference is still good law under this court, and the regulation has defined presentment in this context as being received. Further, under Oyer deference, which would also apply, the regulatory body administering this claim has also further defined what receipt means in this specific context to require specifically that the Bureau of Prison office receives it. And going back to the DOJ program statement, which was promulgated by the director, which is not a codified regulation, but still owes Oyer deference, quote, regional counsel and office of general counsel staff will date stamp all claims on the date they are received. So to the extent that there's any ambiguity regarding when something is received under the previous Code of Federal Regulation, that language clarifies that. And we know that in this case, it was stamped received.
We know that the
February
Supreme
17th.
Court, with regard to the Federal Tort Claims Act in particular, has held that the statutory filing requirements for court can be equitably told. So they have not taken this rigid approach to the FTCA, even as to the statute itself.
Yes, Your Honor.
So why should we be doing differently here?
Yes, Your Honor. There's a distinction between equitable tolling and the equitable rule that is the prison mailbox rule. Equitable tolling does not concern what the language within a statute regarding filing says. So for equitable tolling to be superseded by a statute, the statute would need to specifically say equitable tolling is not applicable here.
But isn't
So-
this just a form of equitable tolling?
No, Your Honor, it's not a form of equitable tolling. This is an equitable rule, a judge-made rule, but unlike equitable tolling, it doesn't require the same specific language. Language saying that receipt is required is sufficient to overcome the prison mailbox rule, unlike equitable tolling. If you
Well,
compare,
that's your assertion, but I'm asking you why it should be any different with regard to its absolute application in the face of equitable considerations with regard to the mailbox rule when it isn't with regard to equitable tolling otherwise.
well, yes, Your Honor, if you look at the context for where the prison mailbox rule came out of, which is the common law mailbox rule in contracts, a contract mailbox rule could be stipulated out of by an offeror by stipulating that actual receipt is to be required. Otherwise, the mailbox rule would be effective upon proper dispatch. The same corollary is at play in the case in the statute of the FTCA, where language requiring receipt does the same effect as stipulating the actual receipt is
But the
required.
common law mailbox rule is a presumption of receipt, but it's not a presumption of receipt at any particular time. It doesn't deal with timeliness.
No, Your Honor, but regarding the presumption of receipt, some circuits have actually applied a rebuttable presumption of receipt to the FTCA and the mailbox rule. For example, Barnett v. Okeechobee Hospital in the 11th Circuit articulated the rebuttable presumption of receipt, but that's not actually reading receipt as ambiguous within the text. That's just an evidentiary concern over ambiguity, over when receipt occurred, given the difficulties of determining that receipt is difficult. But there's no difficulty in determining receipt in this case due to the regulations that define receipt so specifically as when it's stamped
Can I ask you a
receipt.
question? Are you going to address the other issue in the case?
Yes, Your Honor. Regarding the second issue, the ruling in Houston requires the application of the prison mailbox rule only to prisoners who lack a choice with regards to their filing options, not prisoners who lack control over their filings. Otherwise, it would be applied to all civilian litigants who file through the mailbox.
Wasn't Wilson in this case effectively abandoned by his counsel? And didn't he have good reason to worry that he should make the filing himself, given that first he had to wait 2 years for a lawyer. I mean, first the time was running out while his prior lawyer didn't file a timely claim, and then his second lawyer hadn't filed a timely claim. So what is an inmate incarcerated supposed to do in this kind of situation?
Well, Your Honor, with regards to his firing of his first inmate, he could have removed his first attorney. He could have removed his first attorney at an earlier time. He had 2 full years to be able to file this claim. He chose to fire his attorney late within that 2 years. Secondly,
We should hold that against him. I mean, he had counsel that was committing malpractice if he'd let that claim expire without timely meeting a deadline.
well, yes, Your Honor, and you bring up a good point, which is that represented litigants, unlike unrepresented litigants, can seek malpractice as an alternative, unlike unrepresented or pro se litigants who have the.
But malpractice is hardly and a good alternative. Another civil action is hardly a good alternative to losing your claim against a prison and its guards.
Correct, Your Honor. But additionally, with regard to, if we should have sympathy for a respondent, regardless of how sympathetic the respondent is, the statute of limitations exists and is a 2-year frame for a reason.
But here's the problem, though. The direction that the cases are going is in making a distinction between those that have active representation, where the attorney is drafting the brief, is actually doing all the work. There, some courts have said, okay, that makes sense, even the Ninth Circuit. But then after Stillman, the Ninth Circuit said in filing, if it's a nominally represented party, it could be different. So I see our jurisprudence as making that distinction. And it makes sense when you read Houston and the reasons why being a pro se litigant led to that result. So why shouldn't we continue that direction in our jurisprudence?
Yes, so U.S. v. Moore articulated the passively represented litigant, how that they could receive the benefit of the Houston mailbox rule. But critically, they actually still operated within the same logic of a lack of choices. They argued that, a passively represented litigant doesn't have choices with regards to their filing control.
Do any of these cases deal with the filing of an internal claim within the prison system? Can an attorney even file that?
I'm sorry, Your Honor, I don't
Can an
understand.
attorney file this kind of a claim with the Bureau of Prisons, or does it have to be the prisoner himself who files it?
No, the attorney could file this claim, Your Honor. They could file it through the mail system.
Does the prisoner have to sign it?
I believe so, Your Honor.
All right, so unlike, say, filing a notice of appeal or a complaint in court, which is totally within the control of the lawyer, this is really, even if the lawyer conveys it, it is still the claim being filed by the prisoner, as I understand it.
Yes, Your Honor. They would still be filing the claim. The distinction, however, returning once again to the choice versus control dichotomy that the courts have emphasized, the prisoner who files on his own without the attorney's assistance assumes the risk, quoting directly from Houston.
But what I'm wondering is whether this is a different kind of a process in which the prisoner is the active litigant, whether the lawyer helps him or not. It's the prisoner who has to file it and sign it.
Well, the distinction there, Your Honor, is that the prisoner has to sign it. They don't have to file it. The represented
Well,
prisoner
they don't have to be the person who communicates it, but it has to be, it's in their name and not through a representative,
if they're pro se.
as I understand it. Whether they're pro se or not, it is the claim they file, the form is set up so that they file the claim. Is that right? They can have a lawyer helping them file the claim, but it's different from filing a notice of appeal or a paper in court. Am I right about that?
Yes, Your Honor.
So why isn't it treated differently for that reason? That you do need the active involvement of the prisoner in a different way than with papers filed in court, and then you run into the same problems again, even if you have a lawyer. The lawyer has to be able to get the the prisoner to file the paper and get the paper back from the prisoner and so on.
Well, regarding the prisoner's access to their attorney, that still would not create a lack of choice on behalf of the incarcerated litigant, which is the operative logic in Houston, that the incarcerated litigant doesn't have a choice but to file through the prison system. If they're represented, they could still access their attorney in prison, and then the attorney could file their claims on their behalf, despite, as you pointed out, the active involvement of the incarcerated litigant in that case.
But wouldn't it be better if we had a bright line rule that just all incarcerated persons are entitled to the use of a mailbox without a court having to look into whether they were actively represented or passively represented or had been abandoned, even though technically they had an attorney?
Yes, Your Honor. I'm not arguing for the, may I answer this question, Your Honor?
Yes, of course you may.
I'm not arguing in favor of the passive representation distinction. It would be simpler as a factual determination to see if they filed through the prison or if not, to make a determination of whether to apply the prison mailbox rule. However, that would reject the logic that exists in Houston that says that it's the assumption of risk that precludes it from a represented litigant, but allows it to be allows it for a pro se litigant who has no choice but to file through the prison system.
All right, thank you, counsel. Your
Thank you,
time is
Justice.
up.
Thank you.
Thank you, and we will hear now from the respondent, Neil Wilcox.
Thank you, Chief Justice. May it please the court, my name is Jay Naramatsu, counsel for respondent, Mr. Neil Wilcox. The case at bar today is about an inmate's right to have their day in court after weeks, months, and in this case here, years of frustration and hardship. Mr. Neil Wilcox, like 1.8 million Americans, found himself incarcerated in the American criminal justice system. But although confined in prison, U.S. Inmates are still entitled to the right to petition the government for redress. Today, we ask this court to affirm the judgment of the First Circuit and make the following two findings. One, the prison mailbox rule applies to administrative claims under the Federal Tort Claims Act. And two, the prison mailbox rule applies to all inmates, regardless of representation status, if they utilize the prison mail system. This court should find that the prison mailbox rule applies to administrative claims for the following three reasons. One,
I didn't hear your opponent arguing that point. He didn't seem to be arguing that it shouldn't apply to administrative claims. He seemed to be arguing that it shouldn't be applied because of the clarity of the administrative regulation here, but he wasn't generically arguing that it shouldn't apply to administrative claims, was he?
yes, Your Honor. Specifically as it regards to the clarity of the statutes and regulations at issue, one of the reasons this should apply to administrative claims such as the FTCA here is because the text at issue is ambiguous and the complaint does not implicate this court's reasoning in Fex v. Michigan. Specifically, when looking at Section 2401, the statute in question says presented in writing. CFR Section 14.2 further clarifies this by saying when it is received, that is when it's considered presented in writing. However, this notion of received raises many questions, not only for attorneys, but for prisoners, and what does received mean?
I heard your opponent arguing about that we should give some sort of deference to the extent that doctrine is still alive to the regulation in this case. How do you respond to that?
Yes, Your Honor. This issue specifically on how to interpret receive should not receive deference today. As the District Court Circuit of Appeals held in 8 KM v. Secretary of Labor, they noted that defining the statute of limitations is not the sort of provision benefiting of an agency's special expertise. The Bureau of Prisons here is an agency designed to protect public safety by ensuring federal inmates serve their sentences. the defining of when
No,
prison.
but, sorry, counsel, but this was a DOJ reg, right?
Yes, Your Honor, and it's the BOP's interpretation of that or it's a DOJ regulation, but it's the BOP interpreting this regulation.
But didn't Congress expressly delegate rulemaking on these issues to the DOJ? I mean, that's the agency that's defined received. I don't know how much clearer they could have made received. If you have a way that you think they could be clearer, we'd love to hear. But they said in there, received.
Yes, Your Honor. We're not arguing that received in of itself is ambiguous. We're arguing that received by whom is the question at issue. Is it received by the specific office? Is it received by the mailroom? Is it received by the individual or official who can stamp it? Or potentially, is it received by a Bureau of Prison agent, such as the mail guard who received Mr. Wilcox's claim? And curiously enough, the court in Houston here shared these concerns, saying that relying on received raises difficult to resolve questions, such as whether the notice stamped is filed on one day was actually received earlier by that agency. And also, curiously, Congress answers this question further in the same regulation, specifically Section 542.18. There it outlines the admin remedy process. And specifically, they're the administrative remedy process for prisoners who are attempting to file a claim against the BOP. They consider it is received the moment that the request or appeal is considered filed in their administrative remedy index.
Well, how do you distinguish the Ninth Circuit case, Nigro, where the relevant statute required receipt? And, doesn't FEX instruct that Houston policies cannot override the plain meaning of a procedural rule?
Yes, Your Honor. However, we hold that FEX v. Michigan.
We address Nigro first.
Yes, Your Honor. Specifically with Nigro, sorry, can you repeat your question one more time, Your Honor?
Well, how do you Nigro also concerned the meaning of the word receipt, like receive. How do you distinguish that case?
So Nigro is held within a very specific circumstance, and there are other district courts specifically that have held receipt specifically or presented in writing is an issue that is not contrary to the application at Houston. And as a matter of policy, the better interpretation of Houston is that it should require any prisoner, by virtue of their circumstances as incarcerated, should receive more lenient file rulings.
That's why I quoted from FEX where it said Houston policy should not override what a regulation says.
Yes, Your Honor, but
How do you distinguish FEX? And do we just ignore it? Is it an exception to the general rule, or?
Well, Your Honor,
where do we put that?
Yes, FEX v. Michigan specifically doesn't reference Houston in its decision. It is mentioned in the dissent specifically once. Furthermore, FEX v. Michigan involves a very different claim than what is presented here. That was a result of the risk of, they use a balance of the harms approach in determining who is at most risk of suffering harm. There, it was the prosecutors who were facing a deadline and risked not being able to adjudicate the claim. Here, however, Mr. Wilcox is the only one who suffers potential harm from this policy. The risk to the government.
No, I don't know if I agree, Counselor. That was secondary. Primary was an analysis of the language, cause to be delivered, looking at how the IAD was passed, comparison of Oregon and California, and looking at the text, exact language, the tense. Yes, they did get to the policy concerns, but I think what was pretty clear is a clear textual analysis of the language. So what is yours? What is your analysis of the language?
Yes, Your Honor. The issue with the word received is that it's prone to multiple different interpretations, and to an individual unskilled in law, when Mr. Wilcox filled out the SF-95 form, it doesn't point him to a specific statute or regulation to look at to determine whether or not something is received.
So is your ultimate position that the mailbox rule applies to ambiguous language but not to clear language? In other words, if this was even clearer, if the regulation said, and by receipt we mean that it has arrived in the Bureau of Prisons office that is located at some office, some particular place, that would be, then the mailbox rule wouldn't apply? Is your argument just based on the lack of clarity of the language, ultimately, rather than some exception to whatever the language is.
Yes, Your Honor. If the language was specifically clear enough so that a prisoner would understand, in this case, Mr. Wilcox would understand what it has mean to have been received, then he would have been sufficiently on notice to make that determination. However, that is not the case at bar.
So what about, to go back to a question I asked your opponent, we know that the FTCA can be equitably told, not depending on the clarity of the language, but for equitable reasons. But you're not relying on any sense that the mailbox rule is an equitable rule that applies regardless of the language that's governing. You're only relying on the ambiguity of the language. Is that right?
No, Your Honor. We also assert that the respondent's application of the prison mailbox rule better aligns with the legislative intent of the FTCA. The FTCA at its core is about fairness to individuals harmed by the federal government in their body or their property. Previously, before the implementation of the FTCA, individuals could only get recompense by waiver for petition for private bill. The courts have noted that the FTCA provides a more efficient means for individuals to access the courts and to receive said compensation. Amendments in 1966 further intended to promote fair settlement opportunities for these individuals. Yet, as of today, the government's position that the prison mailbox rule cannot apply to administrative claims through the FTCA runs contrary to this very purpose.
Counsel, what do we do about the fact that Mr. Wilson had 2 years to file this claim? And if it's late, if it gets to the agency late, that cuts into the 6 months that only 6 months that the agency has to investigate it or decide whether it has merit, whether it should, pay the claim or litigate it. So is that really fair? Is that really comport with the purposes of the FTCA?
Yes, Your Honor. Mr. Neil Wilcox did not receive the full 2 years allotted to him under the FTCA's provision. Unlike civil litigants who file an FTCA claim, they could, on the very last day, present their claim to the appropriate office in the 11th hour and have it marked as received. Mr. Neil Wilcox and other...
That would be quite difficult and unlikely, wouldn't it?
Well, yes, Your Honor. But the idea that a civil litigant can, in their own hands, take that opportunity to deliver the claim, whereas a incarcerated individual has to rely on the prison mail system or a proxy to do it for their behalf, deserves deference. Here, Mr. Neil Wilcox did not receive the 2 full years. He filed his claim 6 days early, and it was still marked as late. This would require prisoners to determine how long it takes for their claim to get through the prison mail system. That is not a calculus that civil litigants who are...
Of course, well, yes, theoretically, a civil litigant could deliver the claim, but that's extremely unlikely in the current world. And if you try to use the mail, that can happen anyway. We run into all the time the fact that people don't realize that they have to file their notice of appeal, not when they mail it, but when it's received, and they end up very surprised to learn that the mails got delayed and they don't have an appeal.
Yes, Your Honor. However, the issue here is that Mr. Neil Wilcox had to entrust the prison mail guards to deliver this claim on his behalf, the very claim that is potentially alleging that they, potentially harmed him in his body and property. So there's an added incentive for prison guards to make sure that this petition does not go through.
But what do we do about the fact that that Mr. Wilson actually had counsel?
Yes, Your Honor. We contend that Mr. Neil Wilcox and his claim, and it should apply to all represented inmates, regardless if they represented and unrepresented, for 3 different reasons. First, Houston and Rule 4C of the Federal Rules of Appellate Procedure do not specifically exclude represented inmates.
But some of the reasoning of Houston certainly depends on the fact that he was pro se.
Yes, Your Honor.
In Houston.
Yes, Your Honor. While the rule pro se does appear in the Houston decision, the policy arguments behind it are meant to be applied widely to all inmates. Specifically, Justice Brennan in Houston mentioned 3 factors: unskilled in law, unable to leave the prison, and...
Unskilled in law means pro se.
Unskilled in law, yes, Your Honor. Unskilled in law, unable to leave prison, and unaided by counsel.
And unaided by counsel.
Mr.
Now, so if you're I mean, you can argue that this particular person was unaided by counsel, but you want a broader rule that it applies to all or even fully represented prisoners.
Yes, Your Honor. A bright line rule would promote judicial efficiency, and it would provide needed guidance to inmates, a vulnerable population that needs it the most while incarcerated. Currently, courts have to make a qualitative inquiry into what representation means.
Counselor, let me throw you a lifeline on some of this. And I don't mean that in any different way, but the claim was late 3 days, right? The incident, and that's based on the timing of the incident. Part of his claim was that he didn't receive adequate medical care and that he was put back in the general population afterwards when he shouldn't have. So at a minimum, since that conduct occurred afterwards and isn't addressed, at a minimum, shouldn't we reverse and remand to allow to go forward those portions of the claims that didn't accrue, that were within the timeline? Shouldn't that go forward at a minimum?
Yes, Your Honor. However, we would suggest that a bright line rule here would still be applicable, if not for the situation of Mr. Neil Wilcox, but for all similarly situated representatives.
In the ordinary situation of a represented employee, are you arguing that when the lawyer files the document, that the lawyer gets the mailbox rule? Presumably not.
No, Your Honor.
So how often does it arise that a fully represented prisoner is filing his own papers?
Yes, Your Honor. We're not here to suggest that individuals, it's for the unique circumstances of when an individual, and to avoid having to do the analysis of whether or not an individual is represented, because different circuits have held different rulings regarding what representation means. So in order to promote judicial efficiency for the court and to provide guidance for these individuals, we should therefore be able to promote a bright line rule that does
But
that.
are you talking about other, for example, if the prisoner has to send something back to his lawyer, and then the lawyer has to file it, is planning to file it, but if somehow in his sending something back to the lawyer, it gets delayed, are you arguing it applies to that, or only to the filing itself?
No, Your Honor, only the filing itself. If an individual utilizes the prison mail system and their claim goes through the prison mail system
Well, in our court, as a court, a representative person can't file anything. He can't file it himself. If he was actually represented by a lawyer, he couldn't file it himself. The lawyer would have to file it.
Yes, sir.
At least in his name. I mean, it has to be in the name of the lawyer. So there seems like a kind of mini problem in a larger sense, because it should arise almost never.
Yes, Your Honor. And so this bright line rule isn't meant to, it's supposed to apply specifically to the context that we have here at issue in other situations where the court may have to make a consideration on the thorny question of what representation means. If there is a situation where the attorney is the one who almost always has to file it, then this issue should never have to arise. But as we have seen here at the issue before bar, Mr. Neil Wilcox, and whether or not he was represented, was a very big part in trying to deny the right for him to have the access to the prison mailbox rule.
So, but the thing on your facts is that Mr. Wilson had a lot of agency over the situation. He knew his first attorney was, not getting the job done, so he fired him. And he hired another attorney who said they were going to do the job, and that attorney didn't do it. And he knew about the two-year rule. He knew when his deadline was. So why should we absolve him of meeting the deadline?
Yes, Your Honor. If Mr. Neil Wilcox was a regular civil litigant who was making these decisions, there would be no argument that he made these choices. However, the realities of incarceration starkly contrast incarcerated inmates from outside litigants who are represented by counsel.
But that's exactly the point. Justice Brennan in Houston was talking about how an unrepresented litigant in jail can't monitor the timing of when that piece of mail goes through, unlike someone with an attorney. So even though Mr. Wilcox filed it himself. He had an attorney that could have followed that through and could have filed it on the last day if he or she noticed that, she in this case, noticed that, that it wasn't filed. And that was kind of the whole point of Rodriguez Aguirre in the 10th Circuit. And so they latched onto that. Why isn't that the real distinction here?
Yes, Your Honor. The belief that an individual who is incarcerated having an attorney somehow transforms them to having equal standing to a civil litigant outside of the prison works much better in theory than it does actually in practice. For example, incarcerated inmates are subjected to intense monitoring, isolation, lack of privacy, and the remote prisons in of themselves. And so the argument that a petitioner is adequately, or an incarcerated individual is adequately represented, suggests that they can communicate with this attorney always. However, that is not the case. If a prison guard or a prison can prevent someone's claim from being filed on time, they surely can prevent an individual from contacting that said attorney as much or as frequently as a civil litigant could.
But what would have prevented Ms. Fan from tracking it and then filing it on the last day if she saw that her client's form was not received by then?
Sorry, Your Honor, could you repeat that question one more time?
If I have it correctly, Ms. Fan, Mr. Wilcox's attorney, what would prevent her from tracking the filing, or not the filing, the delivery, the mailing, I guess, and seeing that it hadn't been received and then filing it on the last day? I mean, that's what any attorney would do. So there's nothing in the record to show that she wasn't capable of doing that for her client.
Yes, Your Honor. However, Mr. Neil Wilcox, when he filed the form itself, and it's going through the prison mail system, up until the point of where it actually leaves and goes, his attorney cannot track the progress of that form.
No, but that's not the question. The question is, she could, however, have checked with the Bureau of Prisons, presumably, to see whether they'd received it, without even knowing when he mailed it.
Yes, Your Honor. May I finalize
Yes,
the
you may
question?
finish the question.
Thank you. Yes, Your Honor. While it is true that Mr. Neil Wilcox's counsel could have potentially checked thereafter, the matter is that there is still a statutory timeline here. And so if on the last day, to assume that they're able to contact the Bureau of Prisons, get a response that they did not receive it, then turn around very quickly and turn it in that day
She could have
of.
checked the day before the last day, but she also could have filed it. I mean, that's why this case is, you know, the factual premise is extremely strange, because the premise is that she was supposed, I mean, is the premise that she had promised to file it and didn't file it? It's kind of a gap in the facts as they're given to us. Why she didn't file it, or whether she even committed to file it, doesn't seem terribly clear. Do you understand?
Yes, Your Honor. Thank you.
Whether it is clear? Is it clear?
No, Your Honor, it is not clear. However, again, Mr. Neil Wilcox, by virtue of his circumstances as an incarcerated individual, regardless of his representation status, should be allotted for the prison mailbox rule. I see I'm out of time, Your Honor, so thank you.
Thank you very much,
Thank you.
counsel. Okay, counsel for the United States.
A few points in rebuttal, Your Honor. It is a fundamental feature of American jurisprudence that statutes supersede common law rules. Now, respondent has brought up the legislative intent of the FTCA, but the legislative intent of the FTCA isn't really dispositive to the question of
What's the common law rule that we're dealing with here?
the prison mailbox rule.
That's a common law rule. It seems to be a judicially created rule, probably an equitable one.
Excuse me, Your Honor, yes, a judicially created rule, but nonetheless, statutes still supersede judicially created rules. Now, on the issue of the legislative intent, that is not necessarily dispositive.
Well, that depends on what the judicially created rule is, right? If the judicially created rule is one that depends on the language of the statute, that's one thing. If it's a judicially created rule, is an equitable rule that applies despite the language of the statute, then it isn't overridden.
Well, to that point, Your Honor, any judge-made rule could be overcome by specific statutory language. For example, the Tucker Act, which is the contract's corollary to the FTCA, actually does explicitly deny the application of equitable tolling. So while equitable tolling is
But this
applicable-
statute doesn't, and equitable tolling does apply, and it also doesn't specifically negate the mailbox room, which presumably it could, but it doesn't.
Well, yes, Your Honor, but the difference there is because of what it would take to rebut the common law mailbox rule
Counsel, you
versus
said
what
you
it would.
had 3 points, and I think you've only addressed one in your time sprinting down. What are your other 2 points in rebuttal?
I didn't say I had 3 points, Your Honor. I just said a few points in rebuttal.
Oh, you
My
had a few, but
term of
that
art, I
assumes
guess,
that
but,
there's more than one. Is there
but-
more than 1 point in rebuttal?
Yes, Your Honor. The issue related to whether or not the courts, or excuse me, the clear language of the statute supersedes the prison mailbox rule has been addressed, and almost every single circuit that has taken that question agrees that the clear language of receipt in a statute would overcome the common law mailbox.
One
Where-
other
where the-
question that I have is, tell me what is the harm of having a rule that even if the prisoner's represented, if the prisoner does file his own claim, we still allow the prisoner the benefit of the rule, even though we wouldn't allow the lawyer the benefit of the rule.
I'm sorry, Your Honor, I don't quite
Okay,
understand the
what's the
question.
harm of having a rule where the Supreme Court, we can make up the rules. So what's the harm of having a rule that says that even if a prisoner is represented, that if the prisoner does file his own claim, that he gets the benefit, even though his lawyer would not get the benefit?
So the harm related to that aspect of it, Your Honor, is just that it rejects the previous court's decision, and may I answer this question?
Yes, of course.
Upon principles of stare decisis, the court in Houston only explicitly limited it to pro se prisoners who lack the choice
Why would
to
we
file through their
adhere to
attorney.
stare decisis here when we haven't been doing it for the past 2 years?
It's a good point, Your Honor. But I guess my answer to that, Your Honor, would be that the ruling in Houston is good law. It reflects the existing lack of choice that pro se prisoners face, and represented prisoners who assume the risk don't have the same difficulties.
Can I
Your
ask
Honor.
one last question?
Yes, Your
I noticed that you've now argued for how many minutes you've argued, and you haven't mentioned the FEX case. Do you think that FEX is of no use to us, or not?
No, Your Honor, FEX is certainly useful. So the courts which have read FEX to limit the application of the prison mailbox rule, specifically Niagara v. Sullivan in the Ninth Circuit, Smith v. Connor in the Fifth, and Longjet v. Cruzy in the Third Circuit, all of those courts do so on the same argument that I'm making, that statutes can overcome and supersede a common law, or excuse me, a judge-made law.
But is the FEX case really about the mailbox rule that was discussed in Houston? I mean, that was about a limitations period applicable to the prisoner, and again, as in my view, an equitable kind of exception to a limitations period. The period in FEX didn't run against the prisoner in that way at all.
Yes, Your Honor. FEX was involved very unique policy considerations, and so FEX stands for not only the fact that statutory text can overcome Houston if it says as much, but it also stands for the fact that convincing enough policy considerations can overcome the prison mailbox rule.
But why doesn't it stand for something that has nothing to do with the mailbox rule that was created in Houston? I mean, is it even applicable? I thought that perhaps you hadn't mentioned it because you thought it wasn't particularly applicable, and I would tend to think it isn't particularly applicable.
Your Honor, I don't think it's particularly necessary because I think regardless, clear statutory language would overcome a judge-made rule regardless of FEX.
More generically than the mailbox rule.
Exactly.
Just
Okay,
generically.
Thank you, counsel. Your time is over.
Thank you,
and,
Justice.
This session of this court will be adjourned for today. United States versus Wilcox is submitted.
All rise.
turn this back for you.
Yeah. Okay, thank you. All right, you may be seated. All right, another round of applause for our finalists. What an argument. Wow. That bench was hot. So as our judges take some time to deliberate, I want to take some time to reiterate our thanks for the many individuals who have made this competition possible. First, I would like to start by congratulating all of our competitors who have participated in this competition. There would be no competition with no competitors. Your hard work shown through in your briefs and your oral arguments throughout the competition. This year's competition was incredibly competitive, and every cutoff from the brief scores to the oral argument scores was incredibly close. I'd like to reiterate our thanks to all of our volunteers, our professors, the practitioners, and judges who dedicated so much time to our competition. Additionally, again, another thanks to our 1L bailiffs who kept time throughout the competition. We would like to thank our events coordinator, Leslie Dodds, for her assistance in running this whole competition and the countless hours that she put into making this event happen today. Leslie, if you're here, would you raise your hand? Yes. Oh, no, she's not. But a round of applause to Leslie. We'll let her know later as well. Also, a special thank you to Professors Paul Hoffman and Peter Afrasiabi. They provided our brief writing training and our oral argument training to our competitors. A special thank you goes to our advisor, Professor Ross. It is not easy to advise the Moot Court Board. And again, a special thank you to Dean Parrish for his support of the program. Again, we could not function without the generous sponsorship of Buckalter. Running this competition takes a tremendous amount of dedication, time, and heart. And this competition could not have existed without all of you. Without further ado, please join me in welcoming Professor Ross, who will announce the winners of the Best Brief Award and the Best Oralist Score. Thank you.
Thank you, Emily. First things first. For all the hurdles overcome, for all the back and forth, the emails, the phone calls, the meetings, the scheduling, and the rescheduling, the revisions, and the re-revisions, all the obstacles navigated, all the decisions made, and all the deadlines met from back in June. For all that and more, I want to thank the Moot Court Board again. Thank you. Thank you, Emily, and thank you to all the members of the Moot Court Board who made it happen. Now, I think that earlier when Emily said that this event is a culmination, I think that's exactly right. This is a culmination. This is a capstone moment. This is a peak experience. But what of everything that came before? What of the numerous rounds of oral argumentation preceding this one, all of which were judged and evaluated by a panel of judges and practitioners? And what of, even before that, what of the brainstorming, the brainstorming and the research and the drafting? Actually, before the drafting, the outlining. Can't forget the outlining. There was outlining and there was drafting. There was editing, and there was re-editing. There was polishing, and there was the burnishing of the briefs that these competitors submitted. What of all of that? Well, it's my privilege and my pleasure to present the awards for Best Brief and Best Oralist. The Best Brief Award will go to that team of competitors that earned the highest overall scores on their briefs from the law faculty members that graded those briefs. The Best Oralist Award will go to that oralist, that competitor, that earned the highest overall scores for their performance during the preliminary rounds of the competition. To the awards. The Best Brief Award goes to J.P. Elberfeld, Matthew Scamahorn.
Thank you.
Absolutely.
Oh,
Yes. Thank you. Yeah, oh, right here, right here. Okay. Thank you. One more. The Best Oralist Award goes to Carmen Gose. Congratulations.
Thank you so much.
Thank you. And now, okay. So in a moment, momentarily, we will be hearing back from the justices. But for right now, we'll wait. And then when they come back, we'll get a notification. I think that's it. Thank you very much.
right, you may be seated. So we've been asked to give some comments about the orators that we've heard, the outstanding orators that we heard today. And I think I will turn to Judge Berzon to give her comments first.
Well, both of you were remarkably good, I would say. Better than many of the lawyers that we hear routinely in our court. You were extremely well prepared, you were well spoken, and you had thought your cases through deeply and had thought about which points you really wanted to make, and as far as I can tell, you managed to make it. You can tell us later whether there were things you wanted to say that you didn't have the chance to say, but as far as I can say, you managed to say what you wanted to say. The one kind of generic point is that I teach a class on current constitutional cases, and I have this issue with my students as well. When you are purporting to be arguing to the Supreme Court, which we were purporting to be, too much discussion of Court of Appeals cases and distinguishing them and so on is usually not either necessary nor a good idea. If you read Supreme Court transcripts, they're usually not too interested in, unfortunately, in what we had to say. And so in many instances, the answers to the questions, such as Judge Wardlaw's questions about the Ninth Circuit case could be, we think that was wrongly decided and you should not decide the same thing. So there's a tendency to be too tied to what the circuits have said previously. They can be used as examples. Like, we think the Ninth Circuit put the point well by saying such and such, the point that you're otherwise making. But don't get too tied into trying to distinguish or deal with Court of Appeals cases when you're supposedly dealing with the Supreme Court. And similarly, if you're arguing before a Court of Appeals, spending a lot of time worrying about whether this district court or that district court decided differently is not a worthwhile endeavor either. Other than that, I think that there is sometimes a tendency to be excessively tied to being over-prepared, and therefore having your thoughts written out sometimes, or at least so well thought out that you sort of launch into a pre-prepared dialogue which is not really responsive to the questions that are being posed. So the trick is to be extremely well prepared, but also extremely flexible. And sometimes that doesn't happen, and you start repeating something that you've prepared that isn't really what you're being asked about. So that can be a problem. Other than that, I think you were, as I said, admirably presenting your cases, and I at least enjoyed hearing your arguments.
Judge Vera?
Oh, all right, thank you. Well, I echo those comments. I want to congratulate both of you. Fantastic job, great energy, very relaxed, both of you. And let me just give more specific comments to both of you. So first is Gabe, the petitioner, right? So strong command of the cases. I think that was excellent. You knew them backwards and forwards. Your pacing was very good. Good signposting about where you were going to go. Good pivots as well to some of your other points, realizing that you wanted to get to them, and I think that is important. So again, great job on all of that. The second would be Jay, right? That's you. I love that you had a broader theme, that you started with trying to contextualize things a bit more. Sometimes I get attorneys that say, Your Honor, I have 3 points. 1, 2, 3. Well, okay, but why does this matter? What is this really about? some judges care about that more than others, but many of us do. I do, and so I appreciated that. I thought you were responsive also to the questions and that you made some concessions appropriately. So I think you get points when you say, actually, no, or you're right on that. Some attorneys will fight you on everything, even though it's such an obvious point that you should say yes, and then eventually say yes, but, and make your point, not just completely fall on your sword. But I appreciated that you did that. And I also like that you tackled some of the tougher points. I thought, oh, he's going to go to some of the more obvious ones, but you did address some of the ones that really were tough there as well. So again, great job, both of you.
All right. It was a pleasure. I want to echo both the points of Judge Vera and Judge Berzon. I will first address Gabe. So I thought starting out with Chevron was leading with your chin. I didn't think you needed to do that, and it's kind of a weak argument. However, I thought the strategy of avoiding too much reliance on facts and just focusing on the statutory language of this statute was a really smart strategy. I thought you had really good responses to the battery of questions from MSB, as I call her, Judge Berzon. And because you kept coming right back. You were persistent, and I've seen lawyers, real grown-up, full-blown attorneys who passed the bar and practiced many years, not be able to answer Judge Berzon's questions. So I thought you did a really good job on that. And then I thought you picked up well on what Judge Vera was asking when you went right to more. And you did a very good job of doing that as well. Let's see, and the next one was Jay. Okay. Jay, I too liked your dramatic, fact-driven, strong introduction. It sort of drew me in to what you were arguing and to the policies. I mean, it was some judges might think that's over dramatic, and you're going for sympathies. But here, some of the sympathies were actually policies addressed in the Houston opinion. So I thought that was a good thing to do. I think you had a good response to the question about definition of receipt and strong arguments and the realities of incarceration and what that really means. You also, when you didn't understand a question, you asked for it to be repeated. And I think that's a really good thing because you can't answer a question without first listening to it and then understanding what the question is about. Both of you had great understanding of the law and the facts, and I thought you both used adverse questions to pivot really well. So in general, it was very difficult for us to choose between the two advocates here today, but that's our job, so we had to do it, and we're going to give the Best Advocate Award to Gabe Kirsch today. What happens next?
I have one other comment that I didn't make, which is a substantive comment, which is in each case, the one thing that you didn't do was we had to save you so you got to your second argument. That happens a lot. But nonetheless, I mean, in each instance, as I recall, I know for Gabe and I think for Jay, it was only because the judges were watching the fact that you hadn't quite gotten to the second argument when things were, time was running down. It's important that you do that for yourself.
Yeah.
Okay.
Why? I think we've thanked many, many people, but we haven't thanked the absolutely amazing 3 jurors who served as our final bench. Could we have a round of applause for our 3 judges? Great congratulations to our 2 finalists who were absolutely fantastic. We're going to engrave their name forever in our final cup. A special honor that it's the 15th year since our founding that you'll be added to the cup. And then after the audience leaves, we'll have photographs with the awards. At this time, we invite everybody to join us outside where we'll have refreshments. Those who are on the Moot Court board or any of the brief finalists or the final finalists, please stay as we have a lot of photographs to do. Please join me in a round of applause again for the competitors, and thank you for joining us. This concludes the 2024 Moot Court Competition Finals. We'll see you out in the reception. Thank you so much.